haven't called that before. That's good.
Katy's also a lawyer, and she specializes in estate planning, which is an area that seems to get forgotten a lot with marriage breakdown, and so she's going to give us some ideas and some insights to do a better job in that area.
Thank you so much, Linda. So I've got some cards at the front if anybody wants to grab one whenever, that's fine. I practice in Richmond Hill around Yonge and Elgin Mills, but I travel to clients frankly all the time as long as I don't have to drive more than about 45 minutes. Yeah, which doesn't get you too far depending on the time of day. Yes, exactly. Yeah, I don't travel during rush hour traffic. So I'm going to talk to you obviously about wills and estates and estate planning and even maybe a bit of estate administration. I like to take questions as you think about them, and you know, in some presentations I get through like 2 of my 30 slides because the conversation just goes where it goes, and it's usually productive and more interesting than me reading what you can see for yourself on the slides. I usually start by asking who in the room has a current invalid will. And you don't have to, I don't want to breach your privacy. Okay, you guys are educated. You know that you should have one, right? Excellent. How many of your clients have current invalid wills? It's probably more to the point here, right? The Law Society did a study that fewer than half of Ontario adults have a valid will. Not even current. The question was just like, do you have a will? And less than 50% do. As far as powers of attorney go, we're going to talk about those today as well. 25% of Ontario adults have powers of attorney. And that's the stat that blows my mind even more, because you need powers of attorney when you are alive to help you. And if you don't have it in place, I don't know if any of you have had dealings with the public guardian or like the alternate to having powers of attorney, but you don't want to go there if you have any other alternative. They're great people, don't get me wrong, but you're in a bureaucracy now with people that have a lot of work to do and a lot of files to try and get through. I had a client who was, I think he was bipolar. He was off his meds. He ended up in a shelter. They called the public guardian. He ended up being under guardianship. And he had family there who then applied to take guardianship from the public guardian. That process takes a while. And he needed new glasses. He just wore like regular glasses. And he needed a new prescription. And he had to wait 2 years to get the money. His own money. Let's be clear. This wasn't public money. This was his own money that the public guardian was holding to protect him from himself. But just because of bureaucracy, it took 2 years to get glasses. And those of you who wear glasses, you need your glasses. Like, you don't function very well without your glasses, right? So yeah, that's just, I have lots of little warning tales like that coming through. So your clients don't have handwritten wills, do they? Okay, so yes, I get this question all the time. It is legal in Ontario, and I would add, unfortunately, okay? But it is never ever recommended to have a handwritten will. Almost always they cause some form of court application, often turning into full-blown litigation, because usually they're not handwritten by a lawyer. So they're handwritten, I mean, it's clear to the person what they meant, maybe, if they were capacitated, and how do we know if they were, if nobody was in the room while they were handwriting this will. So that gets into its own issues. So when your clients ask you, well, I can just like write my own thing before I jump on the plane, right? Like I can do this in the lobby at the airport, right? You can say, well, technically, yes. But I have cases where I would rather have an intestacy than have to deal with a handwritten document that's going to burn tens of thousands of dollars in legal fees to figure out what that person meant. You guys probably know better than most that marriage revokes a will unless it has specific language in it, like this is Jane's will in contemplation of her marriage to John, which is going to occur during 2017. Like my dad didn't know that he didn't have a will. He got remarried and wandered around for 8 years thinking that his old will was still valid when in fact it wasn't. So I don't know, you probably don't see clients throughout the entire kind of life cycle of what they're going through. You see them at a pretty stressful period of time in their lives. But I mean, divorce only partially revokes a will. Marriage completely revokes a will if you don't have that in contemplation of language in there. So that's just something as a general knowledge point to have. Let me see where we're at here. Yes, how often do you look at your will? Like, you got one, but pretty much Never, maybe, okay, until something happens when you go, did I name that horrible person that I now hate in some role in my will, and do I need to run off to my lawyer and get that changed? And this is just a valid point for your clients as well, right? It's great to have a will, but if it doesn't do what you want it to do, then it's only partially effective. I was working on an estate. We draft wills in my office. We also help executors deal with an estate, like what do you do when the time actually comes? So I never met the testator. She was deceased by the time I was on the scene. She had what we used to call a grand and toy will. I guess now they're on the will kits. Online, there's a million zillion different versions, including all sorts of US versions that people think will be a great will. I don't know. So she had what we would call a grand and toy will, a Staples will probably these days. They have them there too. So it's fill in the blank, and she had filled in the blank. And she had 3 kids, and unfortunately one of her kids died before her, with their own child alive. So you can probably see where this story is going. And this grand and toy will did not provide for the possibility of one of the beneficiaries dying before the testator. And, we can get through some, interpretational problems like that if everybody agrees to play ball. But when money's involved, often people don't want to play ball. So my client was the executor. My client was one of the kids. My client was of the view that her mom would have wanted that grandchild that lost their dad to receive what their dad would have got had he survived. She did not think her mom would have wanted to disinherit the grandchild, right? And that's kind of, the good news about estate planning in Ontario is you basically get to do what you want, unless it's against the law. But we're not like BC. BC has a lot of that's not fair kind of laws around. We don't have the that's not fair law, really. We've got a few things that you can try in court if you want, like constructive trust and resulting trust. But in BC, you can go to the court and say, I got 1/10 of the estate, I'm one of 3 kids, I should have got 1/3, and you're off to the races. You really can't make that argument if that's your only argument in Ontario. Anyway, back to the story. So, my client was clear that we should have still had thirds in the estate, with the third going to the grandchild. One of the other surviving child said, no, the problem is the rule wasn't clear, it was a grand and toy will. He's like, no, I think you and I should each get 50%. Poor John died too early, sorry John. And sorry John's child. And my client basically said, I will fight you to the bitter end on this one, and I am sure about mom's intent. But wouldn't that have been easier? Can you imagine how many hours I spent getting us to resolution on that? At my billable rate, which is not extreme, but any lawyer's billable rate with a lot of hours burns thousands and thousands of dollars. And if mom had just updated her will when her child died, and had done it not through a grand and toy version, but had actually done it properly, all that money would have been saved. Everyone would have inherited more, frankly, if she had. I will always say that it's way more expensive after the fact to try to fix a problem than it would have been, of course, you guys know this, to have done it properly in the first place. Not surprising. Now, do you guys know where your will is, if you have one, or do you think your clients know where the original is? Okay, because, we get very used to, in this, the technological advances of the day mean that, like, actual paper seems to be a thing of the past, not in wills, okay? Wills and powers of attorney, you need the original or nobody's going to talk to you. They don't care about the fact that you have a photocopy of mom's will. Even a notarial copy, and to be clear, a notarial copy is where someone like a notary, some lawyers are notaries, not all lawyers are notaries. There are also notaries that are not lawyers. You need to get a thing from the government saying that you're a notary. But the notary takes the original, takes a photocopy of it, and slaps a certificate on top saying this is a true photocopy, okay? Just to be clear, because people get very confused about what a notary does in Ontario. It's completely different than what a notary does in the States, for example, okay? But even a notarial copy, you'll often get the response of, no, we, the bank, really need to see the original. And if we have to go to probate on an estate, we need the original. If we don't have the original will, we have to file a court application to try to get The photocopy in the lawyer's file, hopefully there is one. Hopefully the lawyer didn't die or move or just disappear off the face of the planet, which seems to happen more often than you think could be possible for people, but they do. If we have to go to court and try to get a photocopy admitted as an original, it's expensive, it's time consuming, and it doesn't always work. Okay, yeah?
So if I die, how will my children know? Like if say I forget to tell them which lawyer, how can they find out where?
That's an excellent question because like people have found wills in freezers. They have found them buried under the tree in the backyard. Like it's ridiculous where people keep their wills. And neither of those is a recommended storage place for your will, obviously. Some lawyers keep wills. Some lawyers, like I, don't. I'm a sole practitioner with a few lovely assistants. If I get hit by a bus, I do not want 1,000 original wills in my possession. This is not good for anybody. But some lawyers do, and they've got a wills vault to keep them safe. Now, the time to have dealt with this is when you're signing your will. So any half-decent estates lawyer at the signing meeting is going to talk to you about safekeeping the documents, like where should you keep them? The usual suspects if it's not a lawyer's office or safety deposit box and fireproof safe in the home. Actually, more often these days, fireproof safe in the home. And of course, being the lawyer, I'll say, if possible, drill down to your concrete floor. I know, who wants to do that? Well, I did that. I've got a safe drill down to my concrete floor, okay? But pros and cons, right? So safety deposit box, it's super secure. So secure that if your name's not on the box, you're going to have a very hard time getting in there. And how many executors' names are on the safety deposit box belonging to the person who died? Sometimes yes, a lot of times no. Okay, so so dad died 10 years ago, mom's got her will in her safety deposit box, only mom's name is on the safety deposit box, daughter is the executor, daughter walks into the bank and says, hey, give me the will, bank. The bank's going to say, where's the proof of your authority to go into your mom's safety deposit box? You're like, well, I'm the executor. And the bank goes, well, how do I know you're the executor? They're like, well, it's in the box. And the bank's like, I can't open the box because I don't, right, chicken and egg. And that can happen for 2 to 3 weeks, okay, back until you get someone at the bank who finally goes, right, we should open the box and take a look at the will, and then they can give you the will. It seems ridiculous. I'll tell you, it happens every day, over and over and over again. So fireproof safe in the home is used often just because it's more accessible. So even if you don't have the key or the combo, you can hire a locksmith in to drill it open. You're going to destroy the safe, and it'll cost $300, but you can get it open and get the will. Now, I haven't really answered your question, which is what if you don't know where the original will is? Well, I strongly encourage my clients to go tell their executors and attorneys for property where they're keeping the original documents. That's the only way that they're going to know where to go get them. But presuming that didn't happen, the usual suspects are lawyer's office, safety deposit box, fireproof safe. Now, let's say you have no idea who mom used as her lawyer. Now you're kind of stuck because there's a lot of lawyers, okay? Especially anywhere near the Toronto area. What you can do is put an ad in the Ontario reports. Lawyers call them the ORs. So if you read the Ontario reports, which you won't because it's really dull and boring, but if you did, you would find the will notices. And the will notices read, anyone having knowledge of the location of the original will for the estate of Jane Doe, please contact this office. And the theory is that every lawyer who keeps original wills in the province of Ontario is supposed to look at the wills notices. And the ORs come out like once a week, once every 2 weeks, something like that. And therefore, they're supposed to look at that, and then they're supposed to contact whomever.
You mean there's no
There is no registry. There is no registry. That's an excellent question, too. Please, there's not one. And people from Quebec are used to notaries and registries, and we got none of that. Original wills get lost every single day. Okay? People die thinking they had a will, and their estate ends up getting processed as an intestacy because no one could find the original will. So it is a huge problem that lawyers don't read the ORs or the wills notices, but even if they did, the problem is that lawyers die, lawyers retire, lawyers sell their practices. When a lawyer retires, or let's say the retirement scenario, they're supposed to try to connect back with every client for whom they are holding original documentation like the will. You're supposed to go find that client and return the original document to the client. Well, how many times do people move over the course of the 20 years that that lawyer's been holding that document? How often do you tell your lawyer that you moved? Like, no, you don't need your lawyer anymore. You're done, right? So the lawyer may have tried to return it, only to not be able to find the client. What lawyers are supposed to do with original wills, where they can't get it back to the client, is now they're supposed to send it to the Ontario court that does have some original wills in its possession, only for that circumstance. So the Ontario court is holding some original wills, but I would say not even a fraction of the original wills that have been done in the province. It's just for that scenario. Well, it seems simple on the surface. I'm not sure in practice it would actually be so simple. So I guess the issue is, so now are we going to say, let's say you had a registry. If you didn't register your will, is it now not a legally binding will? We allow, remember Ontario is so loosey-goosey. We allow you to wake up at 3 in the morning and handwrite a will and fall back to sleep. And that would be a valid will. So you can see going from there to a registry system, like we got a lot of, well, and here's the issue, right? Not everybody, and I wish they did, goes to the lawyer to get the will done, right? So we got the Staples wills, the Grandin Toy wills, etc. Any lawyer who's not negligent is going to have a photocopy of the will. But like I said, you don't get far with a photocopy. It is always, there's no doubt that there's huge problems in the area. And there's no doubt that it could be better.
I just mean in terms of having an executive that at least they have a place to go to try something like that as opposed to just in the office.
Yeah, and the court would be one place. I just think that nobody cares enough about this issue politically to do anything about it. It's going to cost money. You're going to need a process, right? And there's just too many more important issues politically speaking to deal with, I think, is probably the true answer to that. So we have to do it like the logical way, unfortunately, in the way that just says, like, tell your people. It's not that hard. Just tell your people where you're keeping it and then keep it. Like, if you change the location, tell your people. But that doesn't happen, unfortunately, a lot of the time. Okay. Now, some of your clients will have businesses, and some of them will own foreign real estate. A lot of them, in fact, will own foreign real estate, okay? Or they might soon own foreign real estate if mom or dad dies and leaves them the ancestral property and wherever, right? And this is, thankfully, you're not the ones drafting the wills for the clients, I imagine, unless we have estates lawyers in the room. But it's helpful to your client to know that professional advice in this area is super helpful. In the fact that if you have a business owner, then if they do something called dual wills or personal and corporate wills, they can save probate tax on the value of their business. So probate tax. Okay, you've heard of probate tax. Do we understand why it exists or where it comes from or anything? Can I give you the 30-second primer on what probate is and therefore what probate tax actually is? Okay, so what's probate? And this actually goes back to your questions in that, let's say that, so mom's died, okay, the executor is Jane, and let's say that Jane actually does have the original will. Good on you, Jane. Okay, that's awesome. So now, Jane goes to the bank. She knows her mom banked it wherever. She's got the original will even. She's on the ball. Okay? She goes, okay, bank, I'm here. I'm the executor. Give me mom's $80,000 bank account. Or give me mom's, $150,000 trading account, non-registered trading account. Okay? Not an RSP, not a TFSA. The bank is going to look at Jane and go, I can't. And the reason why the bank's going to say I can't is because the bank doesn't know whether the will that Jane's holding is the most recent will mom did or not. We're generally not arriving at the bank with a will done 3 days ago. We're usually arriving at the bank with a will done, who knows, like a year, 5 years, 10 years, 30 years sometimes walking into the bank. So the bank is going to tell Jane, come back when you have a probate certificate. It's actually in Ontario called a certificate of estate trustee with a will, okay? But everybody just calls it a probate certificate because that's way too long. So, and Jane's like, well, why? Why do I need another piece of paper? I have the original will. I thought I was doing really well. Yeah, the bank's going to say, that's not sufficient authority for us, the bank, to give you money. Because if John walked into the bank the next day with a will done 5 months later that revoked the will that Jane walked in with, then the bank's in trouble, isn't it? So if John walks in and the bank said, we don't have the bank account or the investment account because we gave it to Jane the other day, now the bank can be sued because the bank gave Jane those assets without requesting a probate certificate. So what you'll find in practice, I don't know, has anyone had to administer an estate, their parents' estate or friend's estate or anything? Okay. What you'll find is that if the bank account has like $8,000 in it, you can get away with it. So you can walk in with the original will and they'll have you as the executor sign a bunch of indemnity agreements. What you signed, if you didn't read them, and I understand if you didn't, you signed off on the fact that the bank could come back and sue you if the later will, got discovered at some later point in time. They could come back to you and get the $8,000 back from you, okay? So they'll hand over $8,000 on the basis of an original will. They will not hand over $80,000. And you're going to say, well, at what level will they, what's the highest I can keep in there? The problem is it's a discretionary policy. It will depend on the manager, the way the wind is blowing, what they had for breakfast, and how good of a client your mom or dad was or wasn't, frankly, okay? So when I'm TD client. So I walked into TD, and I'm a estate lawyer. I have to ask this question. I'm like, okay, I die. When are you going to start demanding a probate certificate? And they told me on that day, and I have to be clear about that Katie, if all of your single name accounts, non-registered, don't worry about TFSAs and RSPs for now, if all of your non-registered single name bank or investment accounts are greater than $30,000 combined, then we're demanding a probate certificate. You get to 30 pretty fast, okay? So that's why I'm saying 8,000 is okay. 31 isn't. Another bank on another day would have a different number. A very special client would have a different number again, okay? But they tend to not want to answer that question because of the fluctuation in the number. Yeah?
I had just recently somebody that went to the bank and I had them ask that exact question.
Did you?
Because I know
What did they say?
They came back and said, oh, they have an internal policy. They can do up to $206,000. I said, oh, that's great.
Fantastic.
Can we send that?
Yeah.
I just like that. No, we don't have internal policies written. It's an internal policy. I said, if it has the word policy beside it, it's on a document. So they're also very shitty.
Oh, totally. In fact, so people will say, well, I just want to talk to the estates department at the bank. Like, they don't have a phone number. They don't have a public phone number because they don't want your clients to call them, okay? They don't want to burn all of their time answering all these questions from all these people. To eventually, like when I'm working on an estate, I get a little bit more leeway because they know I'm an estates lawyer and they know I'm going to fuss if they push me too hard. But yeah, like the banks have done a very good job at insulating themselves from the actual public when it comes to estate work. There's no doubt about it. Yeah.
I just finishing off my mom's estate. She used a credit union. She only had $5,000 or $6,000 in it. They wouldn't even pay a bill out of it.
Oh, get out, really?
Oh, I was so pissed. They're
Okay.
like, you have to come back with a probate.
Oh, it just makes me want to, that's tough, right? Because a lot of banks will pay the probate tax out of the bank account because they're going to cut a bank draft directly to the Minister of Finance for the probate tax, so nobody else can use the money. They'll generally pay utilities before the probate certificate, but it doesn't sound like they would there. Taxes, like income taxes, if you fuss hard enough, they generally will. Yeah. They did pay the burial fee, yeah. They understand that people, thankfully they usually understand that people need to be, their arrangements need to be covered off. But generally you gotta show them the invoice. They don't take anybody's word for that, right? Now, what you also have to be careful about the online banks like PC, Tangerine. Their discretion is a word that doesn't seem to compute too well for them. So I had an example similar to the credit union one. I think it was Tangerine, where when someone died without a will, they wouldn't release a penny. It didn't matter that there was $2,000 in the account. There's a version of a probate certificate for people who die intestate. They wanted that. to release $2,000. I'm like, wow, okay, we're going to spend in legal fees more than that. And that's what can happen, right? So the banks sometimes get to keep money because it's not worth the legal fees to get the money, which is brutal, in my opinion. So this is how I talk. We go into tangents, but I'm going to bring you back to what probate is. Okay, so the bank has rejected Jane. Was that her name? Okay, so Jane went and she got rejected, and the bank said, you need to come back with a probate certificate. So that's when Jane calls somebody like me, right? Because Jane's like, how do I get a probate certificate? That's what estate lawyers do, is they help executors get probate certificates. So Jane comes to my office. We create a relatively large stack of paper, including the original will. I can't get the probate certificate without a court application if I don't have the original will. So Jane's got to come to the meeting with me with that in hand. And then you can see how that starts to break things down a little bit. So we create the stack of paper, great. One of the other pieces in that stack is a check for probate tax. So I don't get the probate certificate usually, there's some exceptions, but I won't get the probate certificate until the probate tax is paid. So it's not an income tax, it doesn't go to the Receiver General, it's an Ontario tax paid to the Minister of Finance, and it's calculated as 1.5% of the value of the assets that fall under the will. That last little bit I said is actually pretty important. I'll come back to it in a second. In other words, people go, well, don't I get to deduct the debt? Not unless it's a mortgage or a secured line of credit. You can have unsecured debt up the wazoo. You can be bankrupt as far as that debt goes, but you still have to pay probate tax on the value, and it's fair market value as of date of death, of the assets that fall under the will. So people turn themselves inside out to avoid and minimize probate tax, sometimes to their very great income tax detriment, okay? And I'm, we'll get into this as well, but I wouldn't get, it's good to plan to minimize probate tax, but I wouldn't go nuts over it in that there are bigger fish to fry on the income tax side a lot of the time. So Jane's come to me, we've created a stack of paper, she had the original will, awesome. I need that bank draft for the probate tax. We mail that off to the court. This is not, I don't have to go there, thankfully, unless somebody argues, and then I refer it to an estates litigator and they're off to the races, okay? But as long as nobody objects, then eventually we get a probate certificate mailed back to us by the court. And all the probate certificate is a photocopy of the original will with an 8.5 by 11 piece of paper on top with a nice shiny gold court seal that says that this person is the executor as far as we know, and this attached will is the last will as far as we know, signed by the court. And it's a cheap looking thing, frankly, and you spend a lot of money to get it, but it's valuable because when Jane goes back to the bank with that, now they will give her the bank account, the investment account, etc. So that's the probate process. Yeah?
So how do they know it is the last will?
This is the interesting thing about wills is nobody ever knows that it's the last will, right? Especially in Ontario because of this holographic thing that I hate, right? No, this is exactly. So this is the dilemma, and the court has said, well, but we can't just wait forever, right, to see what pops up. We need a process to be able to move on and administer.
No, we need a process to get some money from the state.
Well, probate tax, for sure, it's a tax grab. I'm not going to deny that at all. But even, we said the story of Jane. What if a will had cropped up 5 months later? Well, now we're into it, right? Because now Jane has collected the money. Maybe Jane's not the executor under the new will. Maybe the distribution's different under the new will. Things get messy. So I'll tell you a story from my practice, which on the estate admin side. So again, I never met the testator. One of her sons came to me. There are 4 sons in this particular case. And said, oh, my mom died, and we're looking for a will everywhere, and we can't find one. But they knew that she had a proclivity to handwrite wills. When my client took her to the doctor once, the doctor said, so what do you do for fun? She goes, I write wills. So she would write a will and then do who knows what with it, and then a week later write another will, And so we knew that there was, like, we could have been in the week when after she'd ripped it up or thrown it in the fire, or we could have been in the time frame when we actually, you know how you revoke a will in Ontario? You do a new one that says that the old one's revoked, or you rip it up with intent to revoke, and you know, that's an evidentiary thing, right? I intend to revoke my will. I revoke my will. If I just like dropped it in a puddle and didn't notice and kept walking, I didn't revoke my will, even though it's destroyed just as well as if I had done that. So anyway, we didn't know if she was in the revocation stage of things or whether she actually had a will. Anyway, so they searched all over, couldn't find anything. We went and applied for a probate certificate on the basis of intestacy. 4 sons, her husband had predeceased, and the intestacy law says 4 equal shares. Pretty simple, actually, and away we go. And we got the probate certificate. Nobody fussed too hard. There was an objection, but we dealt with it, and away we went. And I kid you not, like literally the day after I received the probate certificate in the mail, one of the other sons called me and said, yeah, Katie, you know, I'm moving, and I was unpacking a box, and I found a will that my mom wrote. I'm like, oh, you did, eh? And not only, so he sent it to me. It was a 6-page handwritten will followed by a 6-page handwritten codicil, all dated the same day, some in blue ink, some with black ink notation. Like it's a dog's breakfast, okay? I read this and I said, oh dear. So I told the court, I said, I'm mailing you back the probate certificate because this is an invalid probate certificate as of the moment that we know now that there is a will that hasn't been ripped up and destroyed, right, and revoked. So I'm mailing you back the probate certificate. I'm mailing you the will. And here we go. Now that was all in 2012. And it's 2017. And I got the probate certificate this year. Woo! Okay, because that's what handwritten wills are. Everyone would read this and go, what the heck? So whenever you say what the heck, and if you're reading a will, you're going to end up in court, and that's exactly what happened. There was a court application, the litigator took it, dealt with it, we got advice and directions, and away we go. Yes, it was different. And there was an incapacitated beneficiary and blah, 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 blah. And we were really off to the races on that one. And again, like how much of my fees can you imagine got burned? And this was not a big estate. It was maybe a $300,000 estate, which is not, in the context of Ontario, Toronto particularly, given housing prices, not a big estate. But we had to figure it out, because if you're an executor and you don't distribute properly, you can be sued. Executors have personal liability for goofs they make, whether it's an incorrect distribution, and that includes like interpreting the will incorrectly. That's a mistake. If it's negligent, you're on the hook. I had a client just yesterday. We have a will, which is great. We have the original will, even better, except we also have a will. The will's dated May of a particular year, and like 2 weeks later in May of the same year, her mom, guardianship of the testator was taken on by the public guardian. So we have an issue that if mom doesn't have capacity to manage her finances, and therefore the public guardian is in charge, this will may or may not be a valid will. We don't really know, because I wasn't there, right? I don't know what she was like. And so the daughter, the executor under the will, this will says half to my daughter executor, half to my other daughter's kids. And I know that the mother of the kids is going to have an issue with that. She wants her 50%. So my client's like, why don't I just give it to my sister and let's be done with this, right? I don't care. I don't care whether the sister gets it or the kids get it. I'm like, you have to care. You're the executor. If you give 50% to your sister, those kids are going to sue you because there's a will that says that they should have got the 50%. Just giving it to the sister doesn't mean it makes its way to the kids, right? But if we try to probate this will, I guarantee you the sister's going to object on the basis of lack of capacity to make a will. We're between a rock and a hard place on this one. That's still in process. I don't know where that one's going to go. Okay, so that was a very long tangent. And the personal and corporate wills, back to that, the idea is that when you pay probate tax, if you have 2 wills, if they're drafted properly, and that's a big if, I've seen lots of really bad dual wills drafted, but if they're drafted properly, you get to only pay probate tax on the value of assets where you have the bank or whomever demanding to see the probate certificate before they hand over the asset. If you have one will only, you will pay probate tax on every asset that makes it to the will, whether that demand is made or not, including on jewelry. Nobody's asking to see a probate certificate to hand over the pearl necklace, but if you have one will, you're paying probate tax on the pearl necklace. And don't tell me mom gave it away a minute before she died, okay? Because I know that happens a lot. Oh, mom gave it all away. I'm like, the Ministry of Finance expects that people die, women in particular, die owning at least one item of jewelry, okay? So if you leave a 0 on that box, you know there's a probate tax return that has to be filed now, right? It has to be filed within 90 days of getting the probate certificate, and you have to list out all these assets that fell under the will and give lots of detailed information about every single one of those assets. So if you have nothing for jewelry for a woman, that's, in my view, kind of an automatic red flag. Okay? Personal effects, I would say like jewelry and personal effects, throw a number out. Even if it was worthless, throw $1,000 in there and you're done. Much better than leaving saying 0, because everybody dies with something, right? You need the clothing that you're wearing, for example. So the idea, yeah.
Sorry, I wonder if there's a neighbor, we have a family plot at Parkland Cemetery.
Yeah.
And so the intention was that there was a space for me and my husband and my kids and the whole, like generations down the line. So when my mom was really sick, she had ALS, but when she was really sick, just before she started not walking, I took her to the cemetery and had her sign over all those cemetery plots to me.
Right.
And I'm wondering if that's something that would be probatable.
It's an excellent question. It depends. I was going to say it's her property, right? And she gifted, I'm presuming you didn't pay her for them. So that was a gift of the cemetery plots to you before death by her. I mean, honestly, anything that has value is probatable. And if you own something like a cemetery plot, it's an excellent question as to what the fair market value of that was. A contract can have value. So if you die with an agreement of purchase and sale to buy a condo, that says you can buy the condo for $200 and you know those condos are being sold now for $280, I would say that contract even has $80,000 of fair market value. It's assignable to your beneficiary and they're going to make the money. It's this probate tax thing, it's getting very tricky on those more intangible types of assets. I think there's a risk there though. Yeah.
Something like jewelry. How can they prove that there was jewelry? Because let's say
So I would say, for example, where's the wedding ring?
there isn't any.
I would say the proof is always interesting, right? It's not a criminal court though, right? Tax is not proof beyond a reasonable doubt. Tax is balance of probabilities, okay? So if mom was married and there's no evidence that mom gifted the wedding ring, engagement ring, whatever you'd expect mom to have due to that marriage before death, then there's a presumption of like, where did it go, right? So I don't think we're going to see a lot of court cases on it. Probate tax on a $10,000 ring is not enough to get crazy over. But people have been, right after the death, distributing a bunch of artwork and expensive jewelry and not paying probate tax on it. And the issue is that, then we've got the income tax filing. So are you also, for people that are not quite doing probate tax correctly, does that mean they're also not going to do the income tax correctly? Because those two things need to be consistent. So believe it or not, if you own valuable artwork or jewelry that has increased by more than $1,000 in value over time, you're actually supposed to be reporting capital gains on those assets in your income tax return. So are we totally not doing the income tax and the probate tax properly? And as an executor, remember, you're personally liable, yes, for mistakes you make, but also for the income tax, probate tax obligations of the person who died that you're acting for. So if there's a tax issue, you, the executor, are on the hook for it. You can go run to the beneficiaries and say, give me some money back, I gotta go pay like the receiver general, or, yeah, but the beneficiaries are allowed to say, no, I spent it. Like, you're gonna have to deal with this on your own. Executors have a very tough job these days. People used to sort of treat it as a loosey-goosey, whatever, let's kind of, ballpark this thing and away we go. Really, that's a risky approach to take these days to administering an estate. Yeah.
So with dual wills,
Yeah.
if I'm understanding correctly, I should have a will for all my jewelry and all my personal effects.
And your shares of your private corporations would fall under that will as well.
Right. And I'm not going to probate that will.
Exactly. That is exactly the point. But you have another will for your real estate
Right.
and your trading account.
The executor of my second will is going to distribute those assets based on that will.
Exactly.
Okay. So there's no probate owed on that will?
Correct.
But there is going to be, if I have collectibles, capital gains tax owing on that will.
Correct.
Which would then beg the question, I know that the provincial and federal government don't correspond regularly,
But they're going to on this
but they're
issue.
going to.
For sure.
and there's going to be a significant discrepancy
Yeah.
between what I paid probate on.
But you can explain that because of the dual wills. So
and
dual
they'll accept that.
will planning has been around since the 90s.
Yeah, no, I know.
It went to the Ontario Court of Appeal and they blessed it.
Okay.
So yes, there's going to be discrepancy, and that's when you whip out the two wills, right? But if you had one will and you're not, then that's where you have an issue. Exactly. I don't even know who was first. Sure, 1, 2, 3. How about that? Yeah.
When you have dual wills, do not they have to refer to each other's existence in the
Yeah.
primary will?
So here's why dual wills are just. So I'll get people calling me and going, I want to add the corporate will now, and I say, no. You have to redo your estate planning and build both wills simultaneously together because they cross-reference. Generally, how it's best done is that what we call the secondary will, some people call it the corporate will. I don't like that terminology. It makes my clients think that their corporation has a will. Their corporation doesn't have a will. Only people can have wills. It's the assets the will refers to, which is why it's called a corporate. I call them probate and non-probate wills because I like to be really obvious about what we're doing here. So the non-probate will, at its best drafted, I think, grabs every asset where there is no demand for a probate certificate. So common examples are the shares of the private corporations, because we don't tend to need a probate certificate to deal with shares of private corporations. It's in the lawyer's office. Usually a combination of the estate's lawyer, corporate lawyer, do a bunch of documents for the minute book to either wind up the company or transfer the shares to the new owner. Nobody's really asking to see a probate certificate for any of that. The corporation owns the bank account. The corporation owns the investment account if there is one, and the corporation didn't die, right? Now, another asset that falls under the secondary will commonly are private debts. So if mom died and her son Johnny owed her $200,000, that's a private debt. And unless the will says it's forgiven, it's not forgiven, right? That is the job of the executor, is to go collect the $200,000 from Johnny. Or if Johnny has the good luck of being a beneficiary, we can do a set-off, which is good, but it's a $200,000 asset, right? Mom, I know mom doesn't think of it as an asset. She thinks of it as money that's basically gone unless I'm lucky enough to get it repaid. But if it is a loan, and that's always, was it a gift, was it a loan? We can talk forever about that. But if it was a loan, it's an asset of mom's, and probate tax needs to be paid on it if there's only one will. If there's two wills, it falls under the secondary will, good. Got to save probate tax on that. But not everyone, but a lot of people still die owning an asset that does require probate, whether it's real estate, whether it's the trading account. And so often you do have to probate the probatable will, the primary will, but at least you only have to pay probate tax on those assets, and you get to exclude everything else. People have the mistaken assumption that dual wills mean they don't have to go through probate at all or pay any probate tax at all. Sometimes it can work out that way, but I would say generally not.
What do you mean by cross-reference?
So the will says, because the beginning, the preamble of a will usually starts out by saying, first of all, we're revoking every other will we did, and this is my probate will, which is intended to apply to my probate estate. I am also going to do a non-probate will that will apply to my non-probate estate. I intend for both wills to exist. Neither will revokes the other. So you want to be really clear on the verbiage there. And you can see that I therefore can't add another will later. I got to do this at the same time. There's also a few drafting issues, like if we're doing a legacy. So let's say we're giving $500,000 to a charity. I'm not putting that in both wills. I don't want $1 million to go to the charity. I only want $500,000 to go to the charity. So I would generally do that, doesn't really matter, but I would generally do it under the non-probate will. And then I would have what we call a top-up provision in the probate will saying if there wasn't 500 grand in those assets over there, fill it up to the 500 with assets under this will. So that's why everything has to work pretty seamlessly together on that side of things. Did I lose some questions over here? How are we doing?
I
Sure.
think you answered it, or just one feature.
Sure.
So let's just say I have an RSP that's worth $100,000, and Joanne is my beneficiary.
Yeah.
And she's
Go, Joanne.
And she's a non-spouse because we're not that much. And Lucy is my executor,
Okay.
right? So my understanding is that if something, if I reach my demise, my fellow demise, Joanne would get the $100,000, and Lucy would be on the hook for the
You have identified a reason why homemade estate planning often does not work well, right? So yes, and I've used this phrase a few times, assets that fall under the will. And I mentioned it a little while ago. That's an important part of the phrase, okay? Because I will tell people, and I usually do this when I'm talking to clients, I say there's actually 3 ways to inherit. Where I have corporate client, like people with a business, I'll do quadrants. Let's just do that for the sake of argument, okay? So there's 3 ways to inherit. One is via the will. So let's say this particular client has a non-probate will and a probate will. You can also inherit because of joint ownership, and you can also inherit, this goes to your point, because you are the named beneficiary under an asset. Now, of course, you have to survive to inherit under any of these quadrants. Beneficiary designation assets, if the named beneficiary survives, go immediately. They do not hit the will. They go via a completely different legal process than the will. They're gone before the will speaks.
Is that true for bank-held assets with a named beneficiary? My understanding is that a bank-held asset, technically through Beshrauer versus CIBC, flows through the estate.
A bank held out. I'm not sure what you mean by a bank held.
I have an
Tax-free
RSP.
savings.
I have an RSP, TFSA, whatever the case may be in a bank.
Yeah.
TD, you work with TD, and I've got my wife
As the beneficiary.
as the beneficiary. My understanding is that the technical passage of that is through my estate to the named beneficiary.
So there's a lot of, okay, so there's some outlier cases out there where weird things happened and the court came to a result. I would have to look back at that case. I don't have it off the tip of my brain. But if it's a normal situation, the beneficiary gets the money. Now I'm going to talk about, I'm going to table this for the moment, but we're going to go back to adult kids and their parents. That's a different scenario. But let's take the simpler version of a spouse being a beneficiary. So as you probably know, beneficiary designation assets, RSPs, tax-free savings accounts, life insurance, pensions, and I guess seg funds fall under here too, right? These cause huge problems sometimes. Okay, so I had a client, what's a seg fund, right? It's just like it's an investment wrapped in a life insurance wrapper. So it has a beneficiary designation, but unless it's in an RSP, that seg fund causes a tax issue sometimes. So I had a client who named her adult son as the beneficiary of the seg fund, but her husband was the beneficiary under the will. And this was not in an RSP. And seg funds not in an RSP, when the person dies, it's not like an investment account because the contract gets canceled and everything that you own in there, there's a capital gains calculation. So the husband would have got the capital gains tax because he's inheriting the estate. The bill goes to the estate, not to the son. So if this was $100 grand with, say, a $20,000 tax bill associated with it, husband paid the $20,000 tax bill, but son got $100 grand with no withholding for tax. And when I said that to my client, she's like, that's not what I thought was going to. I'm like, I know. That's why you need to change it, okay? Yeah.
I had a client call during tax time. I don't do his tax return, but his wife inherited like from the seg fund, her and her brother. And the brother is the broker, whatever, that sold this kind of investment.
Yeah.
And he was surprised about this whole thing.
Here's the thing. So Okay, I'll give you my mini seg fund rant, and if you guys sell seg funds, I apologize in advance. Please don't use the argument that seg funds will save probate tax because there's a named beneficiary, and aren't they great? Because there's a named beneficiary, and therefore this quadrant applies, therefore the will doesn't apply, therefore no probate tax on the seg fund. And my usual answer is, depending, now there might be some better ones out there, but a lot of seg fund fees are much higher than buying the same asset outside the seg fund, higher than the probate tax savings, in fact. So if you're buying it for the guarantees, that's another analysis. But if you're simply buying a seg fund to save probate tax, you have to compare the differential in fees with the probate tax liability, okay? But yeah, and then you got to really watch who the beneficiary is, and is there a tax obligation on death for the seg fund? People assume not for some reason, or yeah, people get very confused about seg funds.
My comment was like, well, they said it was going to be this much, and now there's a gain of this much, and he's like, there's no way that the money went up by that much, like in the 3 months that the estate got distributed,
It gets,
right?
well, and some of this is the complexity of it. These things, these products, as you know, get so complicated that nobody really understands how they work half the time. And you just take your check and I guess are grateful. I think 1, 2, if you guys don't mind. Yeah.
That point, the seg funds, the
Yeah.
fees are waived on that.
Fees are waived on death. I'm talking about the MER that you're paying every year throughout. Yeah.
So do you address that in the
Sorry. And then you, yeah.
Sorry, we're having the conversation. With
Yeah.
respect to those RSPs,
Yes.
unless they roll over to your spouse, you can have another beneficiary.
Yeah.
At the time of death, they're deemed to be disposed. So in other words, they're cashed in.
Yes.
At the time they're cashed, there's an automatic withholding tax taken from them.
There's no. So let me go to that question because this is a really great question and there's a lot of misinformation out there.
We're still at her.
I know, I'm rolling back to you and then I'm getting to you, for sure. Yeah, and you guys got to help me out that way because obviously I get over there and then you'll bring me back, okay? So RSPs, here's the tax law. Let's do the spouse first and then I'll get to your... So the spouse, if you name the spouse as the RSP beneficiary, then the executor has to be careful, especially if there are other beneficiaries of the estate. The executor has to do a really good job and get professional advice to make sure that the spouse gives instructions to their financial institution to take deceased spouse's RSP money and do a direct transfer to the spouse's RSP. Then you will save tax. If the spouse instead asks for a payout of the RSP, right, because spouses sometimes don't quite know what they're doing, there's tax, and the executor's got to make sure the tax lands in the spouse's lap, and there are documents you can file to make sure it goes down that way. But that's one of the trickier, people think, oh yeah, spouse tax deferral. No, you got to do it right to get the tax deferral, let's be clear, okay, with the right documentation. Now let's take different person, non-spouse as beneficiary of the RSP. $100,000 RSP with a $20,000 tax bill again. So in your example, Joanne, so Joanne gets 100 grand. Your RSP was worth 100 grand when you died. Boom, you get a check for 100 grand, Joanne. No tax withholding. However, when Lucy, the executor, does the tax return for the estate, that tax return includes the 100,000 date of death value of the RSP in full, and that's going to trigger, obviously, a tax liability, which is going to be paid by the beneficiaries of the estate, effectively, and not by Joanne. This is the inherent unfairness of not getting advice, is that you can make all these arrangements and actually not have the distribution that you thought you were going to have because of where the tax liability falls. Okay, so you got to be, when I have a super complicated distribution, I'll often say, you're not going to have a beneficiary of your RSP. You're going to leave it blank or name estate. When you name estate, then the RSP money is going to end up here. And they're like, oh my God, probate tax, probate tax. I'm like, I don't care. 1.5%, yes, is going to go out the door, but then you're going to be able to distribute the 100 grand amongst your 35 beneficiaries, each with different percentages, okay, which is what you wanted. This is the only way that's going to work even remotely effectively. Sometimes the RSP, if you're trying to do charitable gifting through an estate, the RSP is not a bad choice to put the charity as the designated beneficiary. The estate still gets the donation tax credit and you save the probate tax. The charity can't die before you. The charity is an organization, right? So there's various planning that we can do here. But yes, Did I answer the question finally, I hope, at the back there for your scenario? So just to go back to this so we're clear, beneficiary designated assets go out the door before the will applies. Tax-free savings accounts, the spouse should be something called the successor holder, not the beneficiary. Successor holder allows the spouse to step into the shoes of the deceased when it comes to the tax-free savings account, which means the surviving spouse gets to grow twice the amount of money tax-free. Okay, so that's much, much better than being a beneficiary. Sometimes we can file a bunch of documents to try to fix it after the fact. I really wouldn't like to have to bother. I'd much prefer to have them be successor holder right off the bat. Life insurance, as you know, is tax-free.
And the successor holder for like an RP or minor?
Oh, thank you for asking that. No, please don't do that. Okay, so the question was, can we name a minor as a beneficiary of an RSP or TFSA? We can, though, don't get me wrong. You can write down a minor's name on that beneficiary designation. And the problem with all the online beneficiary designation things is people type in all sorts of crazy stuff in there because they didn't get advice. And they're like, I don't want to pay probate tax, so I'm going to name my 9-year-old to get my $400,000 RSP. Okay, so let's break down all the problems with that so that when your client looks at you like you're stopping me from doing what I want to do, you get to say, no, I'm helping you, in fact, okay? So what if the 9-year-old is the beneficiary of the $400,000 RSP? Anyone younger than 18 in Ontario does not have legal capacity. Even if their parent is alive, the parent does not have legal capacity for the child. Okay, I know we think, I don't know who has kids here, but you probably think that, yeah, you can take care of it for your kids when they're minors. Like, you're the boss, you're the parent, like, get out of my face. But the reality of law is you are not the guardian of your child's assets at law. The Office of the Children's Lawyer, which is a government agency, is de facto the guardian of your children's assets. That's why I'll tell you, children shouldn't have assets because, like, at most they should have like a couple grand in an entrust for account and no more. Because what happens when person dies and there's a 9-year-old kid as the beneficiary of the RSP? The financial institution will not pay the 9-year-old. The 9-year-old cannot sign a receipt legally that they received the money. That receipt is not worth the paper it's written on because the kid didn't have legal capacity to sign anything legally binding at all. So now the bank's like, I can't pay the kid. So they pay it into court, as it's called. It's the Office of the Children's Lawyer who really takes it. So and remember, this is even if the parent's alive. The Office of the Children's Lawyer gets the 400 grand. Now they're going to hold it in trust for the minor child. They're going to charge fees for doing that. They're going to invest it very conservatively. They're going to charge fees. And while you as the parent might want to go to the children's lawyer and say, I really need money for hockey. Can I get some of that for my kid? You're subject to their discretion in how it's spent. And then I'll just finish the story. When the child is 18, here's $400,000, 18-year-old. Have fun. Do what you like. Bad, 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 bad. There's no beneficial part of that story, right? Yes, sir. You can buy so there's part of the tax law, and I don't really love this rule because we never use it in Ontario because it's kind of horrible. So to save tax on the RSP, what you can do on death is buy an annuity with the RSP money that takes the 400 and spreads it over the years until the child turns 18. You still have the same issue. You have a child receiving annual payments from an annuity. The child can't sign a receipt for the annual payments from the annuity. So you have this issue whether it's spread or whether it's a lump sum at 400. So, people go, oh, but then I get to use the child's tax rate on the RSP. I'm like, I don't care because you are in the world of the children's lawyer and I don't want you in the world of the children's lawyer. I'd rather pay tax at whatever rate it is and have the money drop into a trust for your child that's created under the will that protects the money till your kid is 30, 35, whenever, okay? I'm a tax lawyer too. That's how I grew my baby lawyer wings as a tax lawyer. And so saving tax is great, and I've spent a lot of time thinking about it and trying to do it for my clients. It's never more important than protecting the money. It's never more important than making sure that your beneficiary gets the money for the things they should get it for and at the times they should be getting it. That's objective number one. Okay? Just to finish the story, so this is joint tenancy on real estate, but also joint bank accounts and joint investment accounts, right? Okay, I'm going to talk to you about the surviving, so dad died, mom is the survivor. Mom goes to a party, and all of her friends are saying, oh, you have to take Jane and put her joint on everything you own because then you're going to save probate tax. We're going to talk about how very problematic that advice is, okay? But just to finish the story, the probate will tends to grab real estate. I'll say large, single name. Bank, my handwriting's horrible. I apologize, okay? It's not going to get any better. Bank and investment accounts. The non-probate will is often shares in private corporations, personal effects. We'll call them personal loans, okay? Just to sort of, now, what I'll tell my clients is, I have a lot of spouses, I want to get to the adult parent thing in a second, but I have a lot of spouses who, when they come to see me, have structured themselves so everything they own is here. If they're getting separated or divorced, what do they need to change immediately? Okay? All of that. This doesn't hit the will. Left-hand side of the paper doesn't make it over here. I can change the will 300 times, but if they still own something in joint tenancy with their ex, the ex gets it. If they still have their ex named as the beneficiary of the life insurance, RSP, whatever it happens to be, the ex gets it. And the RSP is interesting because they're not technically an ex when they're not technically a spouse when they get it. Worse. Now this is a little trickier, right? Because you need your ex to sign off on changes of ownership. So that's going to take a little more negotiation. These are your assets that you own, and you can change the beneficiary designation on these anytime you want, unless you signed a contract otherwise, right? Life insurance, as you know, you've often signed a separation agreement otherwise that your ex is the beneficiary to provide for child support or spousal support or whatever it may be, and that's fine. In fact, when I see my clients, I want to see copies of their separation agreements. And they go, Katie, that was like 20 years ago, and there's nothing going on with it. Why do you want to see that? Like, because I'm supposed to. Okay, the Law Society says I should be getting copies of these things, or I should at least be asking you for copies of these things. If you refuse to give it to me, then that's not my fault. But I did read one where the guy was my client. He'd gotten literally divorced like 30 years ago. So, and I read it, and I'm like, do you know that you're supposed to maintain a $300,000 life insurance policy for your ex-spouse? She had some issues, some mental health issues, and therefore there was spousal support for life that he had agreed to pay her. And as you know, like if you die, there's usually a life insurance policy that drops in to keep being, you know, so she gets a lump sum to at least make up for that. He's like, no, I don't remember that at all. I'm like, I know you don't because it was like 20 years ago. But that obligation didn't fall away because it got old. That's not how this particular agreement was drafted. Child support obligation will fall away a lot of the time, right? The life insurance obligation goes away once the child support goes away, but this was spousal support for life. The obligation never went away. So I said, that previous will you showed me that left nothing to your ex, and this separation agreement is still valid and binding, would have meant that your ex could sue your estate for $300,000 when you die, and therefore your daughters are going to get less because of that. Now the unfortunate fact is he was like 65 when he came to see me. How much is life insurance on a 65-year-old guy? Really expensive, okay? It would have been much cheaper for him to have maintained the policy he had and probably at some point to have converted it to a permanent policy, right? That, at the end of the day, would be cheaper than trying to get insurance now. Anyway, I digress, as you're used to me doing by now. So, yeah.
What happens if people are in the process, because it doesn't happen quickly when they're separating, and somebody dies?
So here's what I tell, thank you. I tell my separated clients, you are in the riskiest position. At least if you're divorced, at least your will is read as if your ex predeceased you, right? So if you had named them as your executor, it's now your alternate executor that acts because you read it as them having predeceased you. If they were inheriting, the usual language is they got to survive you by 30 days to inherit. They're considered to have predeceased, therefore it's your alternate distribution of residue, as we call it. These things need to be dealt with specifically. But I tell my separated clients, you don't have those divorce rules working for you yet as far as the will goes. So your will that left everything to your spouse still speaks. So if you drop dead as part of in the separation process, your ex is getting everything. So, and the problem for the client in that case is that they're overwhelmed with lawyers and expenses and they're like, the last thing I need is another legal thing to have to worry about, Katie. I'm like, okay, but then you need to be okay with the risk. You need to be okay with that as a possibility. So I've done lots of wills for separated clients. They don't love the legal expense when they have so many other legal expenses, but we got to make sure that that money goes to their kids or whoever their ultimate beneficiary is, right? So yeah, it's a really good point. It's the most risky position possible.
What if there's no will and it's just intestacy?
That's an excellent question too. So the intestacy law is that if you die still married, separation means nothing for intestacy law. If you die still married, your spouse, separated or not, gets the first $200,000 of your estate. That means stuff on this side. Plus regular intestacy. Plus it's either a half or a third of the balance, depending on how many kids you have. Only when you divorce does the intestacy law change to everything for your kids, presuming you don't have another spouse.
There's so many people out there that are not officially divorced.
So many, right? So in some cultures you just don't. Like you separate and then you're done and whatever, maybe, because remarriage maybe isn't on the table or whatever. It's super risky.
So from an intestacy point of view, if you have a separation agreement and everything, from an intestacy point of view, there's no concern.
Here's the issue is now you're reading the separation agreement and the intestacy law together. And you guys have seen lots of separation agreements. Okay, some are fantastically drafted, some are not. So one would hope that the separation agreement would override the intestacy law and say nada, nothing. The far safer way to go about it is to do a will that confirms what you actually want to have happen.
So the separation agreement can actually include something that...
Lots of separation agreements go on to say, now I'm not a family lawyer, so I'm definitely not an expert, but basically often if it's well drafted, they're signing off to say that, we're not going to make any claim against the other's estate. Yeah.
Something as simple as that.
Yeah, I'd like to.
For that level.
Yeah, I mean, I would use the intestacy scary story to encourage your clients to go get their will done. Do you know what I mean? Like, it's possible that this could happen. Go get your will done, and that means we don't even have to look at those rules.
How is the decision made with probate? Because I had a client this year died with $4 million. There was no probate. And
Okay.
someone else died with $600,000 and the will was probate.
Now, was your $3 to $4 million client, did they own everything? Was there joint ownership of anything? No joint ownership at all. I would call that an outlier case. Okay, because so the banks have their high net worth areas, they all do, and sometimes, depending on who the person is and the connections, but I'm surprised to hear that probate was waived over $3 or $4 million.
The lawyer said,
That's very risky for the bank to do. Very risky. Now, what I am going to use your question to jump into joint ownership, because that's the far more common way that a $3 to $4 million estate would flow without probate being required. This is the situation where mom or dad died a number of years ago. Mom, what I'll tell my clients is on first death, if you're in a first marriage and everybody's happy, you can probably, if you really want to, do this kind of planning. And I'll tell people, this is great, but I can't protect this with the will. In fact, the will is, if you have everything flowing here, the will is pretty irrelevant, isn't it?
Yeah.
Like you need one, you want to be able to prove you're the executor, that's helpful to have, but as far as actually distributing anything, it maybe applies to personal effects and that's about it.
I always tell my clients, like, they're getting to such, I mean, and not to say you don't want to get complicated or detailed in some cases, but they make all these plans about probate will, and I'm like, so you realize...
But you don't have anything that falls in there. So that happens all the time. Like my clients go, we'll talk, if we have time, we'll talk about spouse trusts and all this fun stuff. I'm like, but there's nothing in the spouse trust, so there's no point doing it. So everybody at the cocktail party goes, well, just make everything joint or beneficiary designated. Boom, boom, we're done, great. And for some first marriage spouses, that is a good plan, especially when they really trust each other, because then I tell them the scary spouse story of if you've done this, and you're first to die, the surviving spouse is the new, complete 100% owner of everything, can do whatever they like with the assets, give them away, spend them, get remarried. Marriage kills the will in Ontario. So that new marriage killed the will that protected, say, your kids or whomever. So what happens on an intestacy if, like my dad, you didn't realize you lost your will, new spouse gets a big chunk of the estate, not the kids. Let's say that they at least knew they forgot, they lost their will on the remarriage. We're really hoping that they do a new will that benefits the kids of the first marriage, but who knows what kind of will they're going to do? We don't know. This is decades later, perhaps. So I'll tell my spouses who do this planning, you are morally hoping, there's nothing legal on this, that the surviving spouse is going to do two things for you if they remarry. The first is a marriage contract, because the marriage contract will let the survivor do a new will that benefits the kids of the first marriage. Without a marriage contract, the spouse is entitled to inherit as much as they would have received on separation or divorce. Do you know that the rule applies on death as well? Same rule, same equalization calculation, all the numbers are the same. So if you came to me and said, I want to do a will that cuts out my spouse, I would ask you, where's the marriage contract that lets you do that will? Oh, you don't have one? Then you are setting yourself up to have your estate be challenged in court by your spouse. This is presuming you're married, right? That you're kind of coming to me without the spouse going, I'm with my spouse, but this is not who I want to have get my money. You are risking huge litigation for the estate. Okay. So, yeah.
If it's a common law couple,
Okay, so separated people and common law people are in the most trouble as far as this stuff goes.
if they're in a common law couple and so they want whatever to go to their children and not to their partner, if they don't have a cohabitation agreement, they run into the same risk?
Well, common law is completely different from married in the area of estates law. So it's an excellent question. That right I said to equalization that married people have, whether it's on separation, divorce, or death, common law people don't have that in any circumstance either. They don't have the right on death either. And so they don't have the rights of married people. Now, you can still deal, even if you didn't have a will, common law people try to do this a lot, okay? But I'm like, the real way to protect your common law partner is to have a will that names them as the beneficiary, because there's no automatic anything on intestacy or anything else, right? Like if they died intestate, that's not a spouse under intestacy law.
Yeah, that's the big sort of misconception because you have...
It's the same.
Well, you have the definition
It's not the same.
for, tax and definition for
So-
RSP rule or yeah.
I will say, the tax definition of a spouse does include common law after a year, or even earlier if you have a kid together. Wow, it's and then I have to tell my common law people, you should be filing your tax returns as spouses, right? And they're like, what? I'm like, you've been living together for 4 years, and for the last 3, you should have been filing as spouses. But I'm like, I know, deal with it, file it properly. And then I have to say that if you, as a common law spouse, want to make a support claim, as you guys know, right, against your partner, you have to have been together for 3 years in Ontario. And that you can make support claims on death too, right? So that's the one area where a spouse, if they've been totally disinherited, which happens on intestacy, or when people just do a dumb will, essentially, right? They can make a claim for support. They can make a constructive trust claim sometimes. You probably have heard people talk about that, if they've actually, to their detriment, contributed to an asset of the estate. But they don't get the equalization. They don't get to make that claim. And they're often, out of luck, common law spouses, when there's no planning and their support network died on them. So I just want to give you, how's my time here? Oh, can I have a couple more minutes? Is that okay?
Oh, yeah.
Yeah, okay. So I'm warning you against encouraging your single client to bring their adult child jointly onto their home, their investment account, their bank account. People do this every day, all the time. And they said, well, somebody told me it was a good idea. And I'm like, was this somebody an estates lawyer? Because I don't think it was. Like, I would find that hard to believe. And the reasoning's always the same. I don't want to pay probate tax. I don't want to go to probate. I need my son, daughter, whomever, to have immediate access to funds. I'm like, I get the last argument a little. I'm like, great, okay. Exactly. Have a $20,000 joint account. I'm not going to get, based on the size of most estates these days, I'm not going to get super fussed about $20,000. But what's been happening with bigger joint assets, which is, John is the guy who helps mom pay the bills and manage the money, and he's the investment guy and whatever, so John ends up joint on everything. Mom dies. John goes, it all belongs to me. Right? All you got to do under the law at first instance, there's a whole trajectory to this, but joint ownership beneficiary designation is you survive by a nanosecond and it's yours. Because it's not the will, it's not the 30 days, yada yada. You survive, you get. So he's like, well, it's mine. And then the sister's like, wait, the will says equal distribution. You and me should each be inheriting 50%. And he's like, well, Mom wanted me to have these, so she put me joint on them, and I guess you're out of luck, sorry. And sister goes to court, and here we go, okay? And that happened like just over and over and over and over again. Until the courts finally, the judges are like, stop. Okay, you're clogging all our court time with these cases. So in a case called P-Cor and P-Cor, which you may have heard of, the court said, we're going to put a presumption of law onto that scenario. The scenario of adult child jointly owning parent jointly owning something with adult child. Doesn't really matter what the asset is. The presumption is that the child does not own any of it, that they're holding it in trust for their parent or for their parent's estate. And you have to rebut the presumption with evidence to the contrary. So you need some evidence, written's best of course, that that was actually a gift that Mom made to John in that case. And it's kind of hard to prove that a lot of the time. We don't tend to have a lot of documentary evidence, and hearsay evidence is difficult if it's in your own favor, right? You're like, well, Mom told me, and nobody wants to listen to that kind of evidence. So when I get, clients coming to me, if they have one will, okay, so they come to me and go, well, I wasn't comfortable with putting Johnny on my house. I'm like, thank God for that, okay? What happens when Johnny goes jointly on the house with Mom? Now it looks like he owns his own house and half her house. Mom had the principal residence exemption on her house. Now it looks like somebody else owns half her house. Johnny only gets the principal residence exemption on one house. He doesn't get it on two houses, and he's going to want to use it on his own house. So now we have tainted the principal residence exemption of Mom. Now, CRE loves that situation, right? They're like, oh, looks to me like half the capital gain from the time that Johnny went on title is now taxable. And we can try and argue P-Cor to have it not be that way, but we're off to the races on that. Also, given what you guys do, what if Johnny gets separated or divorced? Oh my God, like remember the lovely calculation? Like, does half of Mom's house now end up as part of that calculation? He's on title, okay? So whenever Johnny has a creditor of any kind, if he's on title to Mom's, whether it's an ex, whether it's any kind of person who thinks Johnny owes the money, Mom's house is now up for grabs. Yeah.
I have a client that happened to 10, 12 years ago, and I begged them more than not to do it, sent them to an estate lawyer. Now Johnny is going bankrupt, and Daddy's being thrown out of Daddy's house.
Okay. Thank you. You want to come to all my presentations?
And they called me and said, Bonnie, can you help? I'm like,
I tried.
I told you exactly not. Would you
Yeah.
want a copy of the email? It's like, we had this conversation.
Yeah, and you ignored my
I warned
advice.
you not to do it, and Daddy's being...
It's brutal, right? I mean, how heartbreaking is that? Holy moly. Ridiculous. And all to save probate tax? Really? Like, come on. No, no, no.
Because they didn't want the other family member to have any ownership to that. Because the other family wasn't nice. They deserve it.
There are other ways to deal with all these concerns. Far safer ways to deal with all these concerns. So when I've got the client, going, yeah, I didn't put Johnny on the house. That made me feel weird. Good. But I did put Johnny on all my investment accounts, bank accounts, et cetera, so on and so forth. So I get to save probate tax on those, right, Katie? I'll be like, no. You have one will, so your estate's going to probate because of your house. It's a single name piece of real estate. There's a little loophole. You might hear about the loophole. We'll tag that if I have time later to talk about. But the vast majority of the time, real estate triggers probate. Single name real estate triggers probate. Because of P-Cor, because you're going to probate, Johnny is only the trustee of all of these assets of Mom's, all the jointly held stuff. All of that ends up flowing under the probate tax calculation. So you brought Johnny onto all this stuff and raised the risk of Johnny's creditors getting it, and you didn't save a penny of probate tax at the end of the day. You did it for nothing. So we can get intricate with dual wills, probate tax planning, jointing, this or that. But people do all sorts of stuff that just shoots themselves in the foot. When you bring Johnny onto an investment account, who's taxable on the income generated on the investment account? The dividends, the interest. Who's getting the T5s now? Generally, Johnny and Mom are both on the T5. Who's paying the tax? Johnny's like, I'm not paying the tax. What are you talking about? So Mom's like, you can see it's superficially can sound like a good idea, obviously, because so many people do it. The nitty-gritty of it, not fun.
Let alone the disposition.
Okay, so now we've got an investment account. At least principal residence, you've got the exemption working for you. If you really did give Johnny, and this is a good point, right? What if Mom really did want to give Johnny half her investment account when she brought him on? She just, for tax purposes, sold half the investment account at fair market value as of the date of the gift. There's a capital gains tax associated with that, and Johnny's not going to want to pay the capital gains tax for Mom, but Mom didn't get any money because it was a gift. So now Mom's having to liquidate some of her investment account in order to pay the capital gains tax. Isn't this great? So much fun. So yes, we do probate tax planning all the time, but there's a good and a bad way to do it. Yes, did you have a question over here? Are we okay? Look, I think I'm on my first slide still. How awesome is that? Okay, I'm at my fourth bullet point. But I've talked about a lot of the... Yeah.
Foreign property. So
Yes.
the condo in Florida.
Yes, thank you. That was... I didn't...
Going on.
Okay. So, standard advice. First of all, foreign real estate, no matter where the owner lives, is governed by the law of the place where the foreign real estate is located. So the Florida condo is governed by Florida estates law, even though there's an Ontario owner. So now, I draft Ontario wills for people all the time who own Florida condos, to which I say, okay, any estates lawyer is going to tell you the standard advice for any foreign real estate is that if it's a jurisdiction where there is this concept of a will, because some jurisdictions don't have wills. If you go to Turkey and you start talking about having a will, they're going to look at you very blankly. It's a civil law jurisdiction and money just goes where it goes under the law. You don't do a will. It's not how it works. So we can get into interesting issues for places like that. But at least Florida, you know, it's a common law jurisdiction. They have wills. So any estates lawyer is going to say, honestly, the advice is supposed to be get a limited will done by a Florida estates lawyer that deals just with the Florida estate, which is the real estate, plus we usually roll the bank accounts and the car or whatever else into there, because that's going to be far easier to probate in Florida than an Ontario will would be, right? Imagine your Ontario executor trotting down to Florida and presenting your Ontario will to a Florida court and trying to get probate. It happens regularly. It will be successful eventually. It's just after how much time and after how much in legal fees. But I have to tell you that Florida estates lawyers, anybody who knows what they're doing, I've had clients go, I'm going to end up paying more for my Florida limited will than for my entire Ontario will from you, Katie. I'm like, I don't know what to tell you. We're in the U.S. and as you know, U.S. legal fees are exorbitant, especially if you're trying to get someone who actually knows something about cross-border issues. You're in the realm of a specialist and an expert, right? So yes, that's another. I've had clients have 3 wills: probate, non-probate, foreign real estate will, all working together.
So if you get the foreign, if it's in place, then it can go in the non-probate will, correct?
So Ontario probate tax does not apply. It applies to almost everything, but it does not apply to foreign real estate. So that's good news. Okay, that's good news, because you might have to pay probate tax in Florida. Like every jurisdiction gets to decide for its real estate if there's a probate tax liability there. In Florida, we have to worry about estate tax, right? And still, Trump hasn't quite done away with it yet, right? It's a question back there. And here's the, I mean, I don't deal with a lot of Quebec issues.
It's a foreign country.
Quebec is a civil jurisdiction.
That one for Quebec, for like Quebec property, and one for
Yeah, it's easier.
That would be advisable, right? Because it's notaries in Quebec, it's civil law jurisdiction, it's a completely different legal system and process than Ontario. It'll be much easier with a Quebec law to deal with it. How are we doing? Should I go on to my 4th point? Should I take 3 more minutes? 12:25? What do you think? Yeah. Okay. Okay, I already talked to you about that. Powers of attorney, you know your people need them, right? Okay. You don't want the Office of the Public Guardian and Trustee making their health care decisions for them. Luckily, there's a statutory list for that, even if they don't have the document. But you don't want them making the property decisions either. Okay, you guys probably know better than most what an executor does, and we've talked a lot about that today. for those of you who have clients with kids, until the kids are pretty mature, we need them to inherit in trust. So there needs to be a trustee in charge of the kids' money, and that might be the same person as your executor, maybe a different person. I have another structure. So you guys have probably seen the will that says 5% to my kid when they're 21, 30% when they're 28, and the balance when they're 35. We call that a kitty trust. It's great in that it protects and dribbles out, but I have a trust that I like better that I've done for my 16-year-old twins, even though they're only 16. But have you guys heard of income sprinkling trusts before? Income sprinkling, no? Okay. So some yes, some no. So my one son's name is Calvin. So rather than a kitty trust for Calvin, I want a more permanent trust because I like income splitting and I like matrimonial protection. So if I use a kitty trust, as soon as my Calvin is 36, the whole trust business went away, right? He's getting a check. Here's your check. And I like to provide additional protection for Calvin. Now, how I tend to draft these types of trusts, Calvin's 16. He's not a trustee yet, okay? So I've got, whatever. Let's say my trusted person, Maggie, is the trustee. Calvin becomes a co-trustee, let's say at the age of 25. I want him to learn how to manage money. He has managed $10 up to now, and he's going to get who knows how much, right? He needs to learn how to deal with that. But I don't want him to have control at 25. I just want him to start learning. He's done his first degree, okay. And he's sole trustee at 35, the time when a kitty trust would normally come to an end, right? So this trust continues. Now, why do I bother? These are the beneficiaries of the trust. Calvin himself, of course. Also, Calvin's 2 future children. I'm making assumptions here, okay? So let's say Calvin gets a $1 million inheritance. You guys know that's pretty normal, actually, these days, right? Given real estate. And let's say Calvin's a smart cookie and he actually invests his inheritance. Instead of blowing it all, he invested at 5%, he makes 50. If I don't have any of this, if Calvin's 36 and he gets $1 million and he invests at 5% and earns $50,000, who's paying the tax on the $50,000? Calvin. I don't have any choices, right? It's got to be Calvin. The million's tax-free. That's not the problem. We're trying to talk about the income it generates. However, if I have a Calvin trust, any half-decent tax person, be they an accountant or lawyer, is going to say to Calvin, spend as much of the 50, this is presuming he's the trustee, right, and in charge, spend as much of this as you can on your kids, paying for, the daycare, the nanny, the private school, the whatever it is, hockey, music, blah, blah, blah. How much can you spend from a trust? How much can every man, woman, and babe in arms earn in Canada without paying a penny of tax? It's 11 something, right? 3 or 4. Let's call it 11. So you're going to spend at least $11,000 on each of the kids. How much tax is payable on this? 0! Yay! We usually allocate the rest of this somehow to the kids. I let the accountants do the bogus paperwork that does that. Okay. $28,000 is remaining. What's the first tax rate after the tax-free zone? 20%. How much is our tax bill? $5,600 on $50,000. How much tax would Calvin pay on $50,000 if he had to add it to his teacher's income or whatever else he's doing with his life? Let's assume that like 20 of this is walking back to the government in tax, right? 15 to 20 for sure. He's saving 10 grand a year in tax by using this structure, presuming he has 2 kids. If he has 10, it's even better. Awesome, okay? But I hope he doesn't have 10 for the sake of his pocketbook. Now, so that's the income splitting, perfectly legitimate income splitting. And these are minor kids, and you probably heard that, ooh, you can't income split with minor kids. And in a lot of cases that's true, but this is an exception because the source of the money is dead. And that's bad for the person, but it's good for Calvin because that means that he gets to income split with his minor kids. So that's why the tax lawyer in me likes this kind of thing. But matrimonial protection is another reason, because what do kids do with their inheritance? I think the lawyer who was on before, was he a lawyer? Who was on before me, indicated that they spend it on the matrimonial home. And every lawyer says, don't do that, and they do it anyway. They buy a bigger one, they pay off the mortgage, they renovate. So, and there's nothing you can do about that. Like once they've done it, it's done. There's no going back. So when I've got a Calvin trust, I get to say to Calvin, there is one basically safe way to do this matrimonial home funding, and that is to take a mortgage from your inheritance trust. So you're borrowing the money essentially from yourself, but it's a separate legal entity being the trust. You're going to do this legit though. You're going to do it as a mortgage. You're going to register the mortgage on title with arm's length terms. I would even pay the trust the monthly payments. You're paying yourself. Where's the harm? Okay? But as you know, the little twist is that it's the equity in the matrimonial home that's shareable on marriage breakdown. When you slap this mortgage on title, a legit mortgage, the courts look through anything not legit, right? But if you slap a legit mortgage on title, you ground the equity number right down and the shareable amounts right down. And as you know, most debts end up getting somehow repaid or allocated on marriage breakdown. And generally, the Calvin Trust gets allocated assets or repaid for the mortgage if things go bust. So those are the two reasons why I like to have a trust, maybe even for life, for the inheritance, because of eventually the income splitting goes away, right? When these guys are doctors and lawyers, we don't get to income split with them anymore. The matrimonial protection aspect never really goes away, as you know. So when the mortgage is repaid, maybe at that point, you're not having kids anymore, you're not income splitting, you're never looking to buy another matrimonial home ever, Calvin can then pull all the money out and collapse the trust. You can do that, no problem. But that's the kind of structure that I like from a matrimonial protection.
Can you do that at any age, though, beyond 35?
To collapse it? For sure. And that's the only thing that makes it palatable to the adult child to keep it in a trust. Is I say to the adult child, I'm not trying to lock your money away from you. I'm trying to help you protect yourself and save tax. And I hope that I do little, what I call educational moments in my wills. And I'm hoping that through this educational process, you will understand why we put this in place for you and keep it. But if you're 45 and you're convinced you're never going to get married or have kids, for sure, pull it all out, unravel the whole thing. It's no problem.
I don't know if there's an answer to this question, but I mean, is there a point where it makes sense to do this and where it's always...
I think if you've got like 200 grand inheritance, it's not going to generate enough income to get too excited about. And while you might care about the matrimonial protection, once we get over like 250, when we run the numbers, it starts to be worth the candle. I think it was you and then you. Yeah. Yep, you first, for sure. I think those probably bear last two.
And a life insurance trust also be the
Okay.
trust that you're alluding to?
So I love life insurance trusts. I do them all the time. It's a way to have your cake and eat it too. It's a way to save probate tax on life insurance, but also have lovely, intricate trust planning. I do not like the $1 million life insurance policy, Sam and trust for Joni on the beneficiary designation. What is that? It's a trust, probably, because it says the word trust, but there's no provisions, there's no powers, there's no terms. And Joni, if she knows about it, and she's supposed to know about it, can demand the $1 million at the age of 18. So life insurance trust, we can also just not have the beneficiary designation on the life insurance, which pushes the money to the will, and have the trust grab it from there, but that's probate tax bill. 15 grand on a mill. I'd rather do a life insurance trust, drafting fee of 800 and save the 15 grand, personally. But yeah, I like those structures. I think the last question, sorry,
Beneficiary on the insurance contract.
is the life insurance trust. So I'll tell my client, you have to come back and sign all your documents, and now your last job is to go change a beneficiary designation to the trust. Last question.
Henson Trust.
Hanson.
How much do you do with those?
Lots. So if you have a beneficiary for whom disability benefits is relevant, Henson Trust is the way to go. The only way to go, frankly. Now, people automatically go to Henson Trust planning, but I've had a lot of clients say, the Henson Trust is limiting in that the beneficiary can't be the trustee, that's the whole point, and they can't have any right to demand anything, that's also the whole point. So you need a person you really, really, really trust to make the best decisions for your beneficiary. The beneficiary has no right to ask for, they can ask, but they have no right to demand anything. So some of my clients say, look, the disability my kid has, like maybe I had a child who was blind, she's perfectly mentally capacitated. She doesn't need a trust because she's going to blow her. Obviously some disabilities, that kid should never have access to the money. But in this particular case, the mom was like, she's going to want control of her own money, just like her sister will eventually have control of her own money. Disability benefits are not the important thing here. There's enough money in the estate that disability benefits is honestly not that relevant. So For sure, Henson Trust a lot of the time, and the disability benefits aren't the whole story, because when you're on ODSP, you also get a lot of medical coverage that you don't get if you're not on ODSP. So I've had clients go for Henson Trust planning. They don't give a care about the disability benefits, but they needed the medical. So we needed the Henson Trust for that. I think we have to wrap it up for lunch. I know you've got questions. I have a meeting back in Richmond Hill at 1:30, but what I'd love you to do, if you have questions, will you email them to me? I've got cards here on the table, which I'll leave here for you, and it was a pleasure talking to you. Thank you. First slide. Oh, second slide. I got to my second slide. Thank you so much. Oh, thank you. It wasn't all divorce stuff, but oh well.
Thank you very much.